I guess we'll go ahead and start by just introducing ourselves in the panel, and Rick and I are going to be leading off, but I'll go ahead and turn things over to Rick just to provide a brief background.
I've been in the creditors' rights group here at Stites for, 20 years or more now. My practice is in compliance, real estate, and some litigation. Today we're going to talk about the Consumer Financial Protection Bureau and litigation and investigation with them.
And my name is Brian Bennett. I'm also an attorney in the Louisville office in the Creditors' Rights and Bankruptcy Service Group. I've had the pleasure of speaking to this group in years past with my now departed colleague, Katie Bell, who's gone on to the U.S. Attorney's Office. But Katie and I in years past have talked about a lot of the Dodd-Frank issues and a lot of the CFPB regulatory enforcement and rulemaking procedures that have been coming out of the CFPB. And so this is kind of coming full circle for us today to be able to discuss, in light of the new administration, some of the things that are going to be changing down the pipe and trying to use our crystal ball to decide what may or may not happen in the months to come and years to come. My practice is primarily in litigation, but I also do compliance for both residential and commercial clients. Primarily, I'm working on mortgage litigation issues, collections, and really anything touching on the UCC, and I do a little bit less bankruptcy than some of my colleagues that are spread across the room, but also dabble in bankruptcy. And so I'll save some other opening remarks and turn it over to Dustyn to introduce herself.
Hi, my name is Dustyn Jones. I'm a healthcare attorney in Stites' Lexington office. Healthcare attorney is kind of a broad term, so I focus mostly on healthcare transactions, mergers and acquisitions of healthcare entities, and the regulatory overlay that affects those transactions versus a general corporate transaction. I also focus on provider reimbursement issues. I often negotiate with insurers, and I'm in front of administrative agencies trying to collect money for my healthcare clients. That's 80% of it. There's some licensing and regulatory work in there too. Today I'll be talking about the healthcare regulatory climate under the Trump administration. 2 weeks ago, I thought this was going to go a completely different way than it's going to go today, but we're going to, like Brian said, try to look into a crystal ball and give you an idea of what the Trump administration may do now that the American Health Care Act was withdrawn by the legislator.
Good morning. My name is Blaine Early. I'm an environmental attorney in the Lexington office. We take a very broad approach at environmental law. So if it touches land, air, or water, we do things with those issues, whether it's permitting or compliance or transactions, civil litigation, practicing before the state and federal agencies. I'm going to talk about the big changes that have been coming down the pike with the Trump administration and the selection of Scott Pruitt as the EPA administrator. And I'll give you a few more little personal insights when I get to my part of the talk, but just glad to have you here this morning.
Right. So we're going to go ahead and jump in. Rick and I are going to touch on the regulatory climate under the Trump administration, specifically the Dodd-Frank Act and the Consumer Financial Protection Bureau. So as I alluded to, those of you who've been in the room in years past about this time, we've been talking a lot about the Dodd-Frank Act and a lot about the Consumer Financial Protection Bureau. In years past, trying to look at new rules that are being implemented and regulations that are coming out, and enforcement proceedings that are being conducted by the Consumer Financial Protection Bureau, and as well as investigative demands that are being issued, and the CFPB sending examiners into your institutions potentially, or other institutions like you, looking at your affairs. And I know in years past we've tried to do our best to, like I say, use our crystal ball to examine what the rules that are being implemented, how that would have practical effects on your business. I think kind of the overarching, we talked and powwowed a little bit before today, but I think one of the overarching themes in the air with the new administration is this ongoing, and it's been cyclical from the beginning of American history, this over-regulation to the point where it's costly to do business. There's uncertainty and all of these concerns that regulation can lead to. it's too early to say whether this discussion is going to turn things on its head, but certainly I think this is a perfect time for us to be thinking about these things, especially on the financial institution side. Just as kind of background and what we've talked about over the past few years, as you all know in this room, I don't think this is novel to anyone, but the Dodd-Frank Wall Street Reform and Consumer Protection Act was enacted in 2010 in the wake of the financial crisis, obviously. And the goals, stated goals, were to create financial regulatory processes to limit risk by enforcing transparency and accountability. And I think there's a lot, and I won't ask for a show of hands, but certainly there's a lot of industry side folks that believe a lot of the reforms have been, I hesitate to say pro-consumer, but certainly that it's strengthening the rights of consumers, sometimes to the financial penalty of financial institutions. And I think the challenge in this conversation is the fact that you all want to know what the law is, and I think that's what we've tried to do a good job of explaining over the past few years. But it is sometimes a moving target, understanding what the rights of the CFPB have been, and so I think this is a good time to re-examine some of the trends over the past few years. But then one of the big things that came out of the Dodd-Frank Act was the creation of the CFPB, which protects consumers from financial abuse and also consolidated a lot of power that was spread out amongst a lot of different federal institutions and put those consumer protection responsibilities under one primary organization, being the Consumer Financial Protection Bureau. So one of the very first things, literally the very first day that President Trump took office, he implemented an executive order that put into a regulatory freeze any pending regulations. And this was not specific to financial institutions. This applied broadly to, and so it may touch on some of the topics that Blaine and Dustyn will be speaking on, but this applied broadly to any federal regulations that were pending that had not yet made their way to the Federal Register. And so this is not, I don't believe, to be seen as any political maneuvering. Some cynics may say that it is, but this is, in my estimation, a pretty standard action by an incoming administration, especially coming into where the past administration was a different party. And so obviously the intent of this specific act by President Trump was to hold up and allow any regulations that have not yet gone into effect to be reviewed and analyzed and studied by his individuals who at that point in time obviously had not yet been, in some cases, identified, and certainly not, even if he'd identified some of those individuals, not yet nominated or confirmed by Congress. And so the specific impact of this was that it did not affect any regulations that were already in effect. Obviously, a regulation only exists because there's a statute or a congressional act that already puts that regulatory the laws that are created into action. And so it does not unwind. Obviously, the president does not have the ability to unwind acts of Congress. But what this executive order does do is, for any regulations that were not yet sent to the Federal Register, they would not be sent on for implementation and adopted until they were reviewed by Trump's designee or appointment. And then for regulations that were published but not yet reaching the effective date, so they were already in the Federal Register, but the effective date had not yet passed, it allowed a 60-day review for any of those pieces of regulation that were pending in the system. So, as it relates to Rick and my talk, the question is, what effect does this have on financial institutions and specifically the CFPB? And so, I'm not going to steal Rick's thunder because he's going to be talking in more detail about Director Cordray, but Director Cordray of the CFPB has been on since the CFPB came into existence. And Director Cordray's term ends in July of 2018. Rick's going to talk about a recent federal court case that is looking at the constitutionality of the structure of the CFPB and what that may mean going forward and how that may impact Trump and his administration's decision making. But I think for purposes of this discussion and the regulatory freeze, it's just important to note that a lot of the thinking and the analysis of these types of memos in the past have pointed out that there's a general exemption for regulations that are issued by independent agencies. And so because of the structure of the CFPB, and Director Cordray being the head of the Consumer Financial Protection Bureau, there was a question, and remains a question, as to whether regulations that were adopted by the Consumer Financial Protection Bureau are affected by the executive order. And I'm not aware of any fights that have been created yet as a result of this executive order. But that said, until there's some resolution about Director Cordray's future, there is still the potential for this executive order to lead to some battle between the CFPB and the Trump administration.
Yeah, in general, the regulatory freeze applies to executive agencies, and the thinking now is that it does not apply to what they call independent agencies, which certainly includes the Federal Trade Commission, the SEC, the FCC, and perhaps the CFPB and the OCC. The OCC has said that they're going to follow the regulatory freeze voluntarily, even if it doesn't apply to them. But we haven't heard from the others yet what they're going to do.
So anyone who followed the campaign or has continued to follow the first 100 or so days of the Trump administration, I don't know that anyone in this room would be surprised by any of the statements up there. Certainly, and again, it's probably the theme of the day. This whole notion of the costs of regulation, certainly, and certainly, there's a lot of vocal critics of the Consumer Financial Protection Bureau, and some say that it was an overreach and an overstep in response to obviously what was dire financial times, both for consumer and industry side. But at the same time, some people believe that the markets have cooled. Interest rates are going back up. The Fed is starting to change its policies and act in different ways, and so is now the time basically to look back at whether the CFPB and some of its actions and the Dodd-Frank Act, whether those were an overreach, or whether those the possibly well-intended statutory and regulatory framework has now kind of reached its course to where it's having an adverse consequence on financial institutions. So Trump's been a vocal critic of financial reforms in the Dodd-Frank Act. A lot of it, as a lot of the things that we're still learning about on all of these issues, a lot of it's rhetoric at this point, honestly. I mean, there's a lot to be seen, especially when it comes to our discussion as to what this rhetoric, how it may translate into policy. And so that's where we're trying to do our best to give you all a primer on what we expect. And obviously it comes to no surprise to you all. I know you all are aware of Senator Warren from Massachusetts, and she was one of the framers, I think it's fair to say, of the Dodd-Frank Act and Consumer Financial Protection Bureau specifically. And so a lot of those public feuds obviously have escalated the tensions on this specific topic. And certainly once we get around to pending legislation, especially in the Senate, it's going to be interesting to see how some of those past public feuds may lead to feuds on the substantive laws that are being considered by the Congress. I need to keep moving along to keep everybody on task. But another important executive order that came out on February 3rd, so just 2 weeks into President Trump's administration, was what's called an executive order on core principles for regulating the United States financial system. So as it's intended to be, it sounds very lofty. I think that this specific executive order can be viewed as basically a high-level policy statement that's consisting of just a series. On the next slide, I'm going to show you what these core principles are, but it's designed to inform the manner in which the Trump administration intends to implement the regulatory system, and also, if possible, to make modifications. I don't know that the term right now is appropriate to say repeal and replace. Certainly there's some of that in the air in the way of Dodd-Frank, but I think some of the practical realities are setting in terms of where this may go. But that said, I think this executive order from February 3rd is very helpful in understanding kind of how President Trump and his administration is thinking philosophically about about regulation when it relates to financial institutions. Importantly, there are no mandates about specific cuts, and there's actually no specific reference to the Dodd-Frank Act or the Consumer Financial Protection Bureau in this executive order. And so I think it's kind of a policy statement on what he hopes to accomplish in a way that you can kind of understand how he's thinking about these issues. The mechanics of the executive order, before I move on, are that the new Treasury Secretary, who has been confirmed, that he's going to be reviewing over the next 120 days from the executive order, so that puts us into about early June, and then periodically reviewing and reporting back to the President thereafter about the review of these existing laws and this specific conversation, Dodd-Frank, and how Dodd-Frank does either meets up to or does not live up to these core principles. So I'll give you a moment just to review these, and these are also in the materials, but there's a lot of interesting stuff in this, in these 7 core principles. So I think it's important to note that none of these core principles expressly mention the CFPB or consumer financial protection specifically, but there are 4 of these, namely A, C, F, and G, that do implicate the regulation of consumer financial service. And so I do believe that this foreshadows the administration's emphasis on the cost of regulation and the potential adverse economic consequences. And for you all see this every day, obviously. So maybe that means added compliance costs. Maybe that means your all's legal departments are beefing up, or you have outside attorneys such as us that are having to help you scour through these regulatory, these pieces of law that are coming out and helping you decipher what that means on a day-to-day basis for your all's businesses. And so certainly there's uncertainty, and certainly there's these compliance costs that seem to be kind of a theme and at the forefront of what President Trump and his administration are concerned about. I'll move quickly through these pieces because I do believe that Congressman Barr may be I won't say maybe, he is the best person to speak on these specific issues and kind of where things stand. But kind of the roots of reform and kind of looking at our crystal ball as to understanding what especially Republicans are going to hope to accomplish during the next 60 to 90 days. The Choice Act was passed out of the House Financial Services Committee back in September of 2016, and then amended in December. And so it was, I believe, Jeb Hensarling that looked at this as a blueprint for financial regulatory reform. And this touches on some of the things that Rick's going to talk about here shortly. Also talks about some of the ability to repay standards, changing calculations under that, repeal of the Volcker Rule, which relates to speculative investments, and then also providing some relief for community banks and credit unions especially. And then more recently, in February of 2017, there was a memorandum that Chairman Hensarling had drafted that was put out that some have called the Financial Choice Act 2.0. And this is what we believe, at least the House version of a lot of the regulatory reforms will look like. And it is more far-reaching in the consequences of what what House Republicans are looking to accomplish. Specifically, I think one of the things that's worth noting under enforcement tools, there's this idea that we've talked about in years past about UDAP. So specifically, it allows the Consumer Financial Protection Bureau to look beyond, to some extent, what the specific, Truth in Lending Act or the Real Estate Settlement Procedures Act or some of these other financial institution acts, what the technical language says, and allows them to reach beyond that and target financial institutions. And so under the memorandum that was drafted, there's a kind of a departure back to the technical violations, looking at what the statutes actually say, as opposed to this kind of amorphous concept of deceptive acts. And so more to come on that. And again, I think Congressman Barr will probably touch on some of this information. By no surprise, there was immediate backlash. I had to incorporate this some way, shape, or form. But I love this quote from Senator Brown of Ohio that said, "The Hensarling proposal would transform the Bureau from an effective watchdog into a toy poodle." So certainly, there's some political rhetoric back and forth on this, but I think this is important in kind of understanding where the discussion's going to go further on. And so I'm going to turn it over to Rick now to talk more specifically about the CFPB and its structure and the PHH Mortgage Corporation case.
This is a fascinating case, the CFPB versus PHH. As you recall, when Dodd-Frank was enacted, they gave the CFPB a whole lot of authority to regulate financial practices and transactions, and they authorized an administrative system so the CFPB could bring cases in their own administrative court. Most of the cases that went through the administrative court were really just consent decrees. They had investigated a company and they'd come to a settlement, and they used the administrative process just to reach a consent decree and publicize the acts and practices they thought were violated the law, and publicized the fines and civil penalties and restitution that they got. But this case is the first case to actually go through an administrative trial. Now, the CFPB has a choice. Sometimes they bring cases in federal court too, but we're talking about the administrative side here. So this is the first case that actually went through an administrative trial, and they had an administrative law judge, and PHH fought the case very aggressively. It was about private mortgage insurance and a mortgage reinsurance product that they believed was offered for fair market value, but the CFPB characterized as kickbacks in violation of the Real Estate Settlement Procedures Act. And that is kind of technical. I'm not going to talk too much about the RESPA angle of it, although that is fascinating too and could have a lot of impact on how real estate transactions are done. But the other issue that they raised in before the administrative law judge was they challenged the constitutional structure of CFPB. They said that the single director was unconstitutional, that the funding, which is not by congressional authorization, it's from the Fed, so Congress can't affect the funding. It doesn't have the power of the purse over CFPB, and so PHH challenged that. The administrative law judge did not buy it, and he did award $6 million in penalties and rejected the constitutional arguments. Now, what happens, one of the other issues that's kind of strange about the CFPB, the first appeal goes from the administrative law judge to the director of the CFPB, to Director Cordray. Now, he's the one that wrote the complaint in the first place, right? But that's where the appeal goes. It goes to him. And he wrote, the word is he wrote it himself. He didn't have his assistants write it. And he concluded that the ALJ had not gone far enough, that the violations were even worse, and upped the penalties from $6 million to $109 million. And he rejected the constitutional arguments out of hand. And from the RESPA side, RESPA lawyers are very concerned about his interpretations of RESPA because they become very subjective. He says you don't have to prove that kickbacks resulted in consumers paying more for real estate settlement services. It used to be that fair market value was often a defense. Okay, the appeal from the from the director goes to the D.C. Circuit Court of Appeals, and the D.C. Circuit, well, I should say PHH is defending this very aggressively, and they hired Ted Olson. You may remember Gore versus Bush that he argued in the Supreme Court. Well, he argued this in the PHH case too, and very effectively, and convinced the D.C. Circuit that the single director setup, the single director who cannot be removed by the president except for cause, has a 5-year term, cannot be removed. And he argued that that violates the Take Care Clause of the Constitution. The Take Care Clause gives the president the duty to take care that the laws of the United States are enforced. And the argument is, if the president can't remove a subordinate, then he can't effectively administer the laws. He doesn't have control. And so the D.C. Circuit bought that argument and vacated the rules. Now, and it also rejected Director Cordray's interpretation of RESPA, and found that his interpretation of RESPA was a new interpretation, inconsistent with past interpretations, and guidance given by HUD, I guess, at that time. And so a violation of due process to change those prevailing interpretations without notice to the industry. This happened at the end of 2016. In 2017, Trump's inaugurated. The CFPB is very upset with the results of that decision, and so they seek a hearing en banc. And the first D.C. court, D.C. Circuit hearing is before a 3-judge panel. When you get an en banc review, you get all the judges on the D.C. Circuit. It's like 12 or something, and they all hear it again. And so that's what happened. Interestingly, the court is asking specific questions all about the constitutional issues, not about the RESPA issues. But the court asked the Attorney General what they think about it. And so Trump's new Attorney General files a paper entirely different from that filed by the CFPB. The Trump Attorney General says, this is really before Sessions, but says that, yeah, we think the CFPB is unconstitutional as structured too. And so you've got two agencies of the United States government taking different positions in the same litigation. Very, very strange. PHH is arguing that the CFPB should basically be shut down and all their acts are void. The more likely, the Attorney General, and the more likely result is, and the result from the D.C. Circuit panel initially, is that the removal only for cause is a provision that can be severed, and the rest of the agency would be, the actions would be confirmed. This case is going on right now. The oral argument in en banc will be May 24th. I'll tell you what I think is going to happen. I think that the RESPA interpretation of Cordray will be rejected because I don't think it's consistent with existing law. I think that the court will find that the removal only for cause provision is unconstitutional and will sever that and say that the director serves at the pleasure of the president. And so that many of the other actions of the CFPB will ultimately be ratified. But the impact, if that's what happened, the impact will be that Trump will have the opportunity to fire Director Cordray and replace him with a director of his own. I actually think that's more likely to occur than, we'll see what Congressman Barr says, but there's going to be a lot of debate about how the CFPB can be restructured, and it's hard to see hard for me to see that there's going to be a consensus sufficient to get a meaningful restructure. I think you're going to have the same problems as with the Affordable Care Act, but I think we'll just have to wait and see on that.
As noted earlier, there is going to be additional reporting that's happening throughout the spring into the summer months by the Secretary of the Treasury. And so I think Dustyn's portion of the presentation kind of kicked the schedule back for financial reforms, and so and now tax reform is kind of the topic of the day, and so I think in terms of when we would expect to see additional legislation coming down the pike, it would be further into the summer months. And again, Congressman Barr can maybe give us an update on that when he's speaking. But I mean, I think looking at the crystal ball, I mean, it seems as if there's going to be, much like the healthcare fight, there's going to be maybe an aggressive bill that comes out of the House that is going to face an uphill battle in terms of getting passed in that form through the Senate. And that's why we've got our friends Senator Warren and Bernie Sanders, my apologies. And so it'll be interesting to see what happens next. We are out of time, but we did include some additional information on some other important issues that may be of interest to you. So feel free to ask us any questions about these as the day goes along. But we'll go ahead and turn it over to, I believe, Blaine's up next.
Moving from the laws and regulations that directly affect your operations, the environmental climate affects really your customers, whether it's people who have deposits with you, have accounts, ongoing accounts, maybe you're making loans, maybe you're making investments, or maybe you foreclosed on some property and you have to decide if you want to take that risk of actually becoming an owner of that property. So we're going to look first at some changes that we've seen, look at the major policy shifts, and then I want to finish up the presentation with the idea that there are still a whole lot of environmental laws that nobody's talking about changing. They're still in effect, and they affect you every single day. Brian mentioned these executive orders, and just because of the unique posture of the environmental issues, I want to step back and look at those in a little bit more detail. There are presidential executive orders. Brian described some of the ones. One key, and each of the orders that I've seen says expressly that, to the limit of law and Constitution. These executive orders don't change constitutional rights. They don't change statutes. And one key thing especially in the environmental context, is they don't change the Administrative Procedures Act. The idea that you have to have notice and comment rulemaking. Brian talked about rules being published in the Federal Register. And we're going to look at some of the rules that the Trump executive orders have affected, but all of those have actually been passed and are in final rule stage. And that's an important distinction. Then there are presidential memoranda that have kind of broad policy. This is what I'd like to happen. These are my directions. This is what the president says. Okay, Treasury, you go do this. EPA, you go do that, and so forth. And then there's the presidential budget. President Trump has released his budget, and we've seen that the predictions are at least a suggestion of cutting the Environmental Protection Agency's budget maybe 30%, which can have a tremendous amount of impact, not just at the federal level, but also states. And then an actual act of Congress, truly an act of Congress, the Congressional Review Act, it's a relatively recent statute in the mid-90s, at least I think that's relatively recent, that allows Congress to review an administrative rule, and if it acts within 60 legislative days, it can invalidate that. Even though the rule has gone through the entire promulgation process of notice and comment and all, citizen comments and adjustment with industry, they can say, nope, we don't like it, you cannot issue it, and moreover, you cannot issue a rule that is substantially similar, ever, until there is a statutory change. And we've seen one incidence of that happening. Driving all these aspects are some huge environmental policy shifts. We've all heard the phrase, the war on coal. That was a common phrase of Senator McConnell. We have seen, personally at Stites, the environmental group works very closely with the bankruptcy group. And we have been involved in some of this country's huge, major coal company and energy company bankruptcies. Recently, Peabody Energy. Alpha Natural Resources, Arch Coal, Patriot Coal, and before that, the Addington Enterprises. All these happened before, really, the rules that got invalidated by President Trump's recent actions. There are some huge economic natural resources forces that are going on there. But what President Trump has announced is that we will remove all burdens on energy production, domestic energy production. And we're no longer going to take any consideration about this thing called climate change. Now, we're not going to debate whether climate change is human-caused or caused by solar flares or whatever, but by executive order, he has directed the agency to say, do not consider carbon emissions and climate change in your decisions. Major, major changes from, of course, the 8 years under President Obama, and even really under President Bush and then before him, President Clinton. So a couple of specific things that have happened. You've perhaps heard of the Waters of the United States rule, the Clean Water Act. The Clean Water Act, one of the landmark environmental statutes passed in 1972, prohibits the discharge of pollutants from point sources, pipes and things like that, into navigable waters. And then in its infinite wisdom, Congress defined navigable waters as waters of the United States. What does that mean? And there has been litigation really since the statute was passed about what the extent of that waters in the United States is. Under the direction really of the President Obama administration, the EPA looked at a landmark, I guess the most recent Supreme Court ruling on this case, where there was not a majority opinion. There was only a plurality. There only like 4 justices agreed on something. And Justice Kennedy used this term about significant nexus. He said if you can consider something a water of the United States and a navigable water if this water has a significant nexus to a traditionally navigable water. Like, think about the stream that drains the racetrack over here and its connection to the Kentucky River. Nobody would argue that the Kentucky River is a navigable water. You have boats on it. Is the stream that drains the racetrack over here, is it a water in the United States? Well, under the proposed waters rule, it would have been. And just as I'm a water nerd, so I'll admit it. But in the public comments about the development of this rule, of course, it was challenged by a number of people: the American Farm Bureau Federation, house builders, a number of different organizations challenged it. The Farm Bureau Federation commissioned a complex GIS study of how the extent of this proposed rule of the Environmental Protection Agency and the Corps of Engineers would affect Clean Water Act jurisdiction. This is the Ohio River at Louisville. The Salt River is that little stream that comes in the lower right in the southeast. So that's the bend there going into southern Indiana. And if you look at that map, you can see some streams meandering up from the Ohio, up to the north. So that would be a very, very narrow view of waters of the United States. Some would argue that those streams that actually, that you could go out and you could float a kayak down, that those would be waters of the U.S. And what the GIS study commissioned by the Farm Bureau Federation found out, that is, if you applied the definition that EPA and the Corps of Engineers had in this new waters of the United States rule, you get that. All those little red squiggly lines suddenly become waters of the United States, and mean that if you want to bring in some fill material to build a house, or if you want to really do any kind of disturbance, then you've got to take into consideration the waters of the United States and the dredge and fill kinds of requirements. So that was viewed as a very, very restrictive type of approach. So, President Trump's order, executive order, and you have a copy of that in your materials, asked or directed the EPA and the Corps of Engineers to go back and review that rule. And then specifically, and this was kind of odd, the executive order specifically tells the agencies Don't pay attention to the Justice Kennedy significant nexus test. Don't look at whether these waters have some kind of connection, have some kind of link to traditionally navigable waters. Instead, use the Justice Scalia test, where he talks about waters of the U.S. are relatively permanent, standing, or continuously flowing bodies of water. So it's going to be interesting to see how Administrator Pruitt and how the Corps of Engineers now address that on their review of the rule.
Was Scalia's definition, was that in the opinion of the court, or
that was in a concurring in the judgment? Well, actually, there wasn't. It was a plurality decision. The Scalia opinion was joined by 3 other justices. So it was 4 justices saying that Scalia was right. Only Kennedy and Roberts said that Kennedy was right, and then there were some other, some that took the other opinion at all. So in this particular water rule, it had actually been issued as a final rule. It had been challenged in court and had been stayed by the Sixth Circuit Court of Appeals. And so it was already in place. It had gone through notice and comment rulemaking, issued as a final rule, tied up in the courts. And so now the question is, what happens to the rule? We suspect that perhaps exercising administrative and executive power, that the President may direct the Department of Justice not to defend that rule anymore and just go back and review it. So let's go to a rule that is affected by the Congressional Review Act. This is the so-called Stream Protection Rule. We don't see a whole lot of this happening here in central Kentucky, but it certainly affects some of your customers. SMCRA, the Surface Mining Act, controls mining across the country. And it has, in addition to its mining obligations, it has protection of the hydrologic balance. That's the phrase in the statute. Mining has to preserve the hydrologic balance. Again, what does that mean? Think water quality. The Office of Surface Mining, which is part of the Department of Interior under SMCRA, was directed by the Obama administration to look at first what was called a stream buffer rule, and then to expand that into the nicely sounding stream protection rule as an administrative implementation of that phrase in SMCRA of preserving the hydrologic balance. And the stream protection rule, which was issued as a final rule just weeks before President Obama left office and President Trump came into office, dramatically expanded the obligations of hydrologic balance protection outside the mining permit areas, put greater restrictions on the ability to place materials, spoil materials. We got to uncover the coal, and where do you put that spoil material? Sometimes you put it in valleys. Increase the burdens on monitoring and so forth. And there had been a lot of public comment about that as to how that was going to impact the mining industry. Because the timing between the issuance of the final rule in January and the beginning of and taking office and getting in full swing for the 115th Congress, it fell within that 60 days of the Congressional Review Act. And President Trump then signed the order, signed the act that had been adopted as a joint resolution of Congress invalidating the stream protection rule. So now, as opposed to the WOTUS rule, the waters of the U.S., this now means that the Department of Interior cannot issue a rule substantially similar to the stream protection rule unless there is a statutory change. So there's a big, big difference. Now, I included this little continuum here, this little diagram, because we need to keep in mind that what these actions did, President Trump's executive order on the WOTUS rule and the Congressional Review Act on the stream protection rule, all those did was to stop the implementation of rules that had been relatively recently adopted. The stream protection rule didn't even, the ink wasn't even dry on that. And the Waters of the United States rule had been stayed by the courts. So those weren't in effect. And so if you look at this continuum of where we are, way back before the Clean Water Act in the 70s and before SMCRA in 78, there was not a whole lot of regulation. Regulation since then has grown, and we've had a lot of protections and a lot of successes in environmental improvement. So you've got the little line there kind of far to the right. Current rules under the Clean Water Act and SMCRA And then we had the WOTUS rule and the SPR, or the Stream Protection Rule. So just because President Trump has directed the Corps and EPA to review the WOTUS rule, and just because Congress has invalidated the Stream Protection Rule, that doesn't mean that environmental protection of water has gone away. So all these news reports and the bemoaning by the Sierra Club and the Natural Resources Defense Council saying, oh no, the sky is falling and we're going to have terrible destruction of our waters, that is just not so. Because those same kinds of requirements for permits and dredge and fill permits, and still you run a risk if you loan money on a development project and you haven't made sure that your developer has gotten a jurisdictional determination that they're not going to be building a building in a wetland, then you're in trouble. So all those protections, all those environmental obligations are still there. It's not a free-for-all for anybody. All right, let's go to the executive order about the so-called Clean Power Plan. Now this is consistent with those two major policy issues: removing burdens from the production of domestic energy and reducing the impact of or reducing the consideration of climate change. This executive order just issued the end of last month. Again, specifically used those words about reducing burdens. It directed the EPA to go back and review the so-called Clean Power Plan. It directed the Department of Interior and the Bureau of Land Management, that own and control federal lands for which they lease oil and gas and coal developments, to rescind orders that limited the leasing of those federal lands. And there are some other issues in there about the production of methane, reviewing rules on the production of methane from mines and from natural gas and oil operations. But most specifically, the one that's had the most, I guess, press, the most concern, is the Clean Power Plan. Again, this is a set of rules adopted under the Clean Air Act aimed at reducing carbon dioxide emissions, and specifically carbon dioxide emissions from fossil fuel plants. Read coal, oil, and natural gas. The upshot of the rule is that it makes it almost impossible, if not completely impossible, to build a new coal-fired power plant, because no coal-fired power plant could have the low 1,300 pounds of carbon dioxide emissions per megawatt that was required by the Clean Power Plan. Again, this had been issued in the Obama administration time. It had been challenged in the courts, currently stayed. There are a lot of issues. Is it constitutional? Is it directly related to the statutory language, and so forth? But it's still hasn't been implemented yet. So all those bankruptcies we talked about, Peabody Energy did not go bankrupt because of the Clean Power Plan, and LG&E has not adopted its solar, utility scale solar facility. East Kentucky Power has not done its solar facility because of the Clean Power Plan. There are other forces at work there. So if the Clean Power Plan, if EPA reviews that and says, yes, we're not going to do this, we're not going to issue anything like this anymore, still the pollution controls of the Clean Air Act in terms of restrictions on mercury, restrictions on sulfur dioxide, all those are still in place. It's expensive to install those protections. Doesn't change the price of natural gas. Natural gas at $2 MCF, that's a whole lot cheaper than bringing coal from Pike County, Kentucky, to burn it. So the fundamental economics aren't going to change. On the policy side, if we do end up, sort of backing away from the Paris Accord, you've heard about that in terms of climate change. If we do end up nixing the Clean Power Plan completely, how's that going to change our role? Interestingly enough, Peabody Energy, largest coal company in the country with substantial operations in Australia, I understand that the executives of Peabody are approaching the Trump administration saying, hey, maybe we don't want to get out of Paris. Peabody is hoping to ship enormous amounts of coal to India, to the Korean Peninsula, to others, so that they don't want to be in a position of fighting our international colleagues. So it's going to be an interesting kind of juxtaposition here between some of the major domestic energy producers and the world. So then finally, just to end up, just a couple of minutes, just to remind you, nobody that I've heard of in the Trump administration or in the new version of the EPA has suggested any changes in some very fundamental things you're all familiar with. There are still going to be obligations under SMCRA. So you're still going to need to do phase 1 environmental site assessments. You still have to worry about, is there a chemical dump on this property that I might foreclose on? There's still going to be requirements under the Clean Air Act. So we're not going to have to worry about, breathing soot. Those protections aren't going to go away. The Surface Mining Act is still in place. The Endangered Species Act is still there. You're still going to have to check to see with the archaeologists if your planned development is going to affect a historic or cultural site. None of those are changing. But big changes on sort of these broad policy things of energy production and rules and regulations that specifically address those. So that's the end of this part of the program, and I'll be around if you have any questions. You do have, for your reading pleasure, and if you need to go to sleep tonight, copies of the 2 executive orders. And it's interesting to see what they actually put in there. So again, I look forward to your questions later on. So Dustyn.
So I'll be talking about healthcare under the Trump administration, and healthcare is complicated. So like I said, 2 weeks ago, I thought this was going to go an entirely different direction because we thought we were going to pass, the Republicans were going to get through the American Health Care Act. They actually withdrew the bill, and so we are still operating under the ACA, but we'll talk a little bit about both laws and how the Trump administration can still affect change without the American Health Care Act in force. So the problem with healthcare is you have equally important competing interests and a struggle to balance them. So we have access. Lots of people need health care, and many of those people don't have enough money for the health care. We want quality health care, so we need adequate, efficient medical services that work to heal us, and we need to keep the cost in check because eventually somebody's going to have to pay for it. So we want low-cost, quality health care for everyone. The reality is, again, somebody has to pay for it, and it costs too much. So to hold costs low, we sacrifice quality and or access, and when access and or quality increase, the costs are too high to bear the burden. So what's the solution? And you notice this slide is blank, and that's on purpose because we're doing our best to find one, and we have the ACA, and we're working on that. So the Obama administration's solution to the problem was the Affordable Care Act. The main tenets of the law, and I'm going to keep this pretty high level, is, it requires individuals to have health insurance or pay a penalty, so everyone has to be in the market. It makes the regulations more economically feasible. It requires large employers, 50 full-time employees or more, to provide health insurance to employees. It establishes state and or federal health exchanges to facilitate the purchase of insurance that's required by the Act. Mandates that insurers provide essential health benefits, basic maternity care, preventative services, emergency care, mental health, prescription drugs. They can't sell bottom-of-the-barrel insurance policies. Your insurance policy actually has to work when you purchase it. And it also expanded Medicaid. So the ACA did a lot of good things and is doing a lot of good things. The uninsured rate in the U.S. is below 10% for the first time ever, with coverage reaching 20 million Americans. This has a direct impact on Kentucky itself. In 2013, 17% of Fayette County was uninsured, and now we have 6% uninsured. It increased access to health care for those previously uninsured and those with pre-existing conditions. It reduced the burden on emergency rooms. People without health insurance, when they're sick, they still need care. So they show up in emergency rooms, and hospital emergency rooms end up bearing the burden of their health care costs. So when they have insurance, when individuals have insurance, they're more likely to seek preventive care, and they can see private physician offices, and we're getting them out of the emergency room. There's issues with it. Again, we've increased access, but now we have to figure out who can pay for the access, right? So premiums continue to rise. The premiums in the initial year, I believe the quote is they're 20% higher last year, and we suspect they're going to continue to rise in 2018. These are the policies that are sold on the exchange. Choices continue to decline. Humana and Aetna have pulled out of the market because it's not financially feasible for 2018. And other insurers are contemplating options for 2018 still, so that remains to be seen. Many counties have only one insurance plan to choose from. That includes most of Western Kentucky. So there's a map that's color coded. One insurer is light pink, 2 insurers is dark pink, and 3 insurers is red. Most of the central Kentucky, where you have some bigger cities, we're looking at red. All of Western Kentucky is white. One insurer option for the counties in Western Kentucky. And like I said, many insurers are contemplating pulling out, or they're at least contemplating on getting rid of their platinum plans, which are the Cadillac policies with lots of benefits but are more expensive. So in response to the ACA's failings, the Trump administration attempted to pass what they were calling the American Health Care Act. It eliminated the individual mandate, but replaced it with a 30% premium surcharge for 1 year on individuals who go without insurance. So the economics of the law is not going to work unless healthy people are in the market. Because if only sick people are in the market, the cost is going to be too high for the insurers to bear. So the legislator attempted to remedy this problem by requiring everyone to get into the individual market, so the costs are offset by healthy people paying premiums. Their healthcare cost is low, they're still paying premiums. So if we get rid of the individual mandate, it destabilizes the economics of the law. So what do we do? So the Trump administration said, okay, we'll replace that with a 30% premium surcharge. So if you're not in the market and if you have a gap above, I think, 64 days, where you don't have health insurance, if you go back into the market, then you have to pay 30% premium, a 30% higher premium for the next year. So it disincentivizes individuals to go without health insurance and to only purchase health insurance when they're sick. It eliminated tax penalties, but replaced the penalty with a tax credit. It rolled back mandated required benefits, so it lessened the regulations on insurance companies to provide those essential health benefits. It limited federal reimbursement for Medicaid by changing to a per capita system. So the federal dollars that go to states to help pay for Medicaid, that's going to be a block grant. You get $1 million, and you have to figure out what to do with that $1 million. So it squeezes access and quality because the insurance companies are incentivized to not provide care because it increases the profits, right? So they also want to block grant it within certain categories of individuals. So disabled, elderly, childless adults, and pregnant women. So it's going to squeeze on different subsets of the state. It also rolled back the Medicaid expansion, but it also increased savings limits on health savings accounts. It didn't pass. Republicans withdrew the bill on March 24th when they realized they didn't have enough votes to pass the law. The problem, conservative Republicans wanted more. They wanted less government regulation and to lower costs to insurance companies more than the law did. So they wanted it to go further. The moderate Republicans thought the bill went too far and that too many people will be left uninsured. So what now? So the Trump administration could try to pull the teeth out of the ACA. So they don't need Congress to destabilize the regulatory oversight that implements the ACA. So they could cut off federal subsidies to health insurance companies that are meant to offset losses to insurers for keeping premiums low. So the government gives two subsidies, one to the individual to help pay the premium and one to the insurance company to help them offset the cost for providing insurance at a low premium rate. Right now that issue is pending in district court. Or it has been, I'm sorry, it is not pending in district court. A district court judge has ruled that those subsidies directly to the insurance companies are unconstitutional. And it is now up to the Trump administration and not the Obama administration to fight that appeal. So the Obama administration appealed that decision, and now it's up to the Trump administration, who doesn't like the ACA, to defend the ACA and the subsidies that make the ACA work. So they could just decide not to fight that hard. They could refuse to enforce the penalty for the breach of the individual mandate. So the IRS enforces the penalty for the breach. The Trump's IRS could say, we're not going to enforce these penalties. If you go without insurance, you know, that's fine. We're not going to make you pay. They could redefine the regulatory interpretation of essential health benefits. So right now, essential health benefits, like I said, insurance companies have to offer preventive care, emergency services, prescription drugs. The definition of essential health benefits is a regulatory definition and not a statutory definition. So by regulation, they could alter that definition to reduce the costs on insurance companies because they would have to offer fewer benefits. They could approve state waivers to deviate from the ACA, so they could let states get around it. Or they could refuse to keep the framework running. So it's expensive. The exchanges are expensive. The helpline. Already the Trump administration eliminated advertising towards the end of the enrollment period. And the enrollment in the 2018 plan year is much less because individuals were not aware of the fact that the enrollment period was going on. So there's ways they can circumvent the ACA. They could also try to make it work. They could take what we have and try to propose a solution to making the current law work. They did file, they being the Trump administration, did file some amendments to the AHCA since this was done last Wednesday. So they could also try to put up another bill. So there were further amendments filed April 6th. So we'll see. That's where the crystal ball comes in. We don't know. So, do you all have any questions for any of us?
I have a question. How is this going to impact the healthcare providers in Kentucky, our hospitals and our doctors groups and whatnot?
Well, I mean, right now everything's business as usual, right? So, I mean, right now everything should stay the same. Now, if they start to, if the market starts to get upset, if the Trump administration starts to pull the teeth out of the ACA, it will likely revert back to, fewer individuals insured, less health care for the individuals, more burden on the emergency rooms. But that's all kind of conjecture.